The Constitutional Court has handed down its judgment in the Jacob Zuma MK matter. This was the matter that was looking at whether or not Jacob Zuma could potentially go back to parliament if his party, the MK party, receives enough seats. And here's what the Constitutional Court had to say. And after I play this, I'm going to also play you the reaction of the president because he heard this news while he was at an interview live on 702. So here's what Judge Theron J., who read the judgment, had to say.
In the main application, this court finds that its constitutional jurisdiction is engaged because Mr. Zuma's eligibility to stand for election turns on the proper interpretation and application of 47(1)(e) of the Constitution. This court finds that it is in the interests of justice to hear this matter because the consequences of the contempt judgment, and in particular the effect of a conviction and sentence on eligibility for the National Assembly, is of public importance. The general public needs to know if candidates on a party list are eligible to be members of the National Assembly. In respect of the merits, this court finds that the purpose of the disqualification in section 47(1)(e) is aimed at maintaining the integrity of South Africa's democratic regime, which is founded on the rule of law, by ensuring that members of the National Assembly possess the requisite respect for the rule of law. This court finds that the purpose of the proviso is to allow the appeal process to unfold. It is aimed at ensuring that a person is only disqualified from standing for and holding office once their conviction and sentence are final. It does not prevent a sentence that is final and immune from appeal from being a sentence for the purpose of section 47(1)(e). The reasoning of the Electoral Court in finding that the sentence that was imposed on Mr. Zuma could not be said to be a sentence which the section contemplates cannot be sustained. This is because it has no support in the text of section 47(1)(e). Section 47(1)(e) applies to anyone who has been sentenced to more than 12 months imprisonment. The text does not qualify the word sentence and sentenced to exclude sentences imposed by this court. The Electoral Court's judgment and the respondent's contentions are tantamount to equating until in section 47(1)(e) to unless. The interpretation of section 47(1)(e) of the Constitution adopted by the Electoral Court subverts the purpose to be achieved by the section. In relation to the legal effect of a remission of sentence, this court finds that section 47(1)(e) focuses on the length of the sentence imposed, not the length of sentence served. The section uses the words convicted of an offence and sentenced. The effect of a remission of sentence is to bring forward a person's date of release. Remission of sentence concerns the execution of the sentence and does not retrospectively alter the sentence imposed by a court. Thus, for purposes of section 47(1)(e), remission of sentence is irrelevant. In respect of whether the Commission exceeded its powers, this court considered the relevant provisions of the Electoral Act. Section 30, sub 3 of the Electoral Act requires the Commission to decide the objection, while Section 27 of the Electoral Act deals with a party's list of candidates. Section 27(2)(b) requires that lists must be accompanied by a prescribed declaration from a representative of the party, and I quote, that each candidate on the list is qualified to stand for election in terms of the Constitution, close quotes. The form for a candidate list is prescribed in Appendix 1 to the regulations concerning the submission of lists of candidates 2004. It requires that a party's list must include an undertaking from a party representative that, and I quote, each candidate on the list is qualified to stand for election in terms of Section 47 of the Constitution, close quotes. The court finds that in terms of these provisions of the Electoral Act, the Commission is empowered to determine, before the election, qualification for membership of the National Assembly. In relation to the question of bias, on the part of Commissioner Love and or the Commission, the respondents submit that there is a reasonable apprehension of bias on the part of the Commission to the extent that the Commission as a whole was legally excluded from deciding the question of Mr. Zuma's eligibility to stand as a candidate in the election. They rely on a statement made by Commissioner Love to the media in relation to Mr. Zuma's eligibility to stand as a candidate in the election. Commissioner Love was quoted to have made the following statement on 24 January 2024 at a press briefing when a question was specifically asked about Mr. Zuma's eligibility to stand as a candidate. And this is what she said. That excludes anybody who has been given a sentence that was not subject of any deferral, and in that sense, it is not ourselves, but the laws of the country that would stand as an impediment for that candidacy, close quotes. This court finds that the Electoral Court correctly found that the context in which Commissioner Love was speaking for the Commission was ambiguous and without specificity. In respect of the question whether Mr. Zuma was convicted as contemplated in Section 47(1), this court finds that there is no difference between a conviction following criminal proceedings and a conviction following civil contempt of court proceedings, since a person is convicted of a criminal offence in respect of both proceedings. Section 47(1)(e) draws no distinction between convictions for civil contempt and other convictions. Therefore, the ordinary meaning of an offence should be given to the word, that it is a criminal offence. It is not for a court to limit the scope of the provision. The section clearly says, convicted of an offence and sentenced to more than 12 months imprisonment without the option of a fine. Mr. Zuma was convicted in that this court found him guilty of the crime of contempt of court. This court concludes that Mr. Zuma was convicted of an offence and sentenced to more than 12 months imprisonment for the purposes of Section 47(1)(e) of the Constitution and is accordingly not eligible to be a member of and not qualified to stand for election to the National Assembly until 5 years had elapsed since the completion of his sentence. In the result, the following order is made. The applicant is granted leave to appeal directly to this court. It is declared that Mr. Zuma was convicted of an offence and sentenced to more than 12-month imprisonment for purposes of Section 47(1)(e) of the Constitution and is accordingly not eligible to be a member of and not qualified to stand for election to the National Assembly until 5 years had elapsed since the completion of his sentence. The order of the Electoral Court is set aside and replaced with the following, and I quote, "The appeal is dismissed, close quotes. The counter application is dismissed. There is no order as to costs in this court." I hand down the judgment.
Order, Jen.
About your research and whether or not you can make a turn to we will actually have to pick up from right there. We just have to reading the Constitutional Court in front of the particular matter about your research and whether or not you can make a turn to we will actually have to pick up from right there. We just have to reading the Constitutional Court in front of the particular matter about your research and whether or not you can make a turn to
Atikelema is the president's spokesperson. She was very happy. He was careful because he was looking and he was smiling. Then he saw that the camera is going to pick up his reaction. Then he looked away. So think of that what you will. So what my reflections are on this particular judgment, and we must note, once the Constitutional Court makes a determination, that's final. This is the end of the road for Jacob Zuma within the legal arena. And it seems to me that the court has chosen to protect its integrity. It has chosen to uphold its own reasoning in Zuma 1 and in Zuma 2, and it has chosen to avoid contradictions and to accept any of the arguments that were made by Concourt and Zuma and even by the Electoral Court would have been a tacit concession that there was some form of an error, either in the procedure that was chosen by Chief Justice Raymond Zondo to come to the Constitutional Court as a court of first instance, or in the reasoning in Zuma 1 and Zuma 2. I think the court chose not to undermine itself and to uphold its own integrity. And they may have made this decision in part because you don't want to create uncertainty about the legal reasoning of the court, in the sense that you want to maintain the respect and gravitas of the court. Many people had raised issues with Zuma 1 and Zuma 2, particularly with the fact that, Zuma's rights to appeal were not afforded to him, and that he was incarcerated for a civil offense, which also had skipped a step. Because if you recall, the first thing that you need to do is a coercive order, which is to say you didn't go to a particular legal forum. You must go to that forum. Otherwise, you face imprisonment. That is what is known as a coercive order. And then if you don't do that, there is a committal order where we then say go to prison directly. In Zuma 1, what the court then did was to say, we're going to skip part 2. We're going to assume that Zuma is not going to go to the State Capture Commission. And also because he has been disrespectful to us, we are going to uphold the respect of the court and send him directly to prison, which is what they did. So as things stand, Jacob Zuma cannot go to parliament, and he will not be able to lead Concourt from the parliamentary benches. There's a question about whether he wanted to go in the first place because he could have lost his presidential privileges. There's a question also about how much impact you can have as a leader outside of the parliamentary benches. If you think about Helen Zille, she is the leader of the Democratic Alliance. She's head of their Exco, something like that. Can't remember the title. But effectively, she is in charge of the Democratic Alliance along with John Steenhuisen. And she has a lot of influence, but she does not have the same level of daily scrutiny as somebody who's a leader in parliament would have. So it may be beneficial for Jacob Zuma to actually not go to parliament because he's a little bit older and he may not be willing to do the day-to-day grind of being a member of parliament in opposition or in whatever capacity he was going to go in. Right. So it's also significant that Theron J read the judgment. Maybe she volunteered herself. Maybe she led the reasoning. And also, I think it's significant because she dissented in 1 and 2. And she was one of the people asking some of the most hard questions to Advocate Tebeka Ngwaitobi and also to Advocate Dalipofu. So one of her concerns was the undermining of the original decisions of the court, particularly it being the Constitutional Court, if you recall, from the questions that she was asking. And it seems as if by her doing this, it resolves that tension which existed on the bench between Theron J, Jafta J, and the other judges. So as things stand right now, the court has shown that it is unanimous and it is ad idiom, of the same mind about these particular issues. So now this is the law, and this will be the law forever in South Africa. Let's discuss what Umkhonto weSizwe has achieved with its lawfare. What have they achieved? They've used the court process as a rallying point. This starts off with the first electoral court decision, the Durban High Court decision, the second electoral court decision, and now the Constitutional Court decision. These cases have been covered by media, by people such as myself. They've been attended by members of Umkhonto weSizwe, and they have been used as a rallying point for the party. The party would not have gotten the same amount of media attention and energy if these cases had not been covered. This is known as earned media. Earned media is the media that you get for free from prominent media houses and people without having to pay for it. And it is the opposite of, paid for media. Another form of media is owned media, which is the media that you own and you distribute on your own platforms. So these court cases have enabled Umkhonto weSizwe to be one of the leading stories in the build up to the election. And even now, 9 days to go, they are still a large part of the conversation. So in as much as Jacob Zuma and MK lose at the Constitutional Court, this has been a journey where the legal process has led to lots of benefits from them. They've prevented the deregistration of the party. They've prevented the loss of use of the name Umkhonto weSizwe and any other paraphernalia around imagery. So the logo and everything that they've chosen to use, they can still continue to use. Zuma is still the face of the party. As we know, it was clarified by the IEC that as the leader of the party, his face will be on the ballot. For the Gogos and many people who just vote when they see the face of a person that they love, they're still going to see Jacob Zuma. They're not going to be confused about which party it is. They're going to know that Jacob Zuma is the leader of this party. They're going to vote for him. And in fact, for many people, it may also make them more resolute and determined to actually say, I think that our guy has been targeted and victimized, and we're therefore going to vote for him. We're seeing the same thing happening in America. A lot of people thought that Donald Trump would lose support as a result of the multiple cases of litigation against him. Turns out he actually gained lots of support, and people who support him and are diehard supporters support him even more because Donald Trump has told them, I'm being attacked by the system, I'm being attacked by the deep state, and as you can see, they're coming for me. And that has helped him secure leadership of the Republican Party, and as we know, he's now running for the main ticket to be president. And some polls show that he has a very strong chance, and Joe Biden is struggling, even though there's litigation that is within courts, and he's charged and facing criminal charges. So those who support Jacob Zuma and the MK party will still be able to express their dissenting vote, and many of them may even feel more galvanized to do so. They may have more enthusiasm. We'll see. There's no way of telling. Right now, Umkhonto weSizwe is now in a similar position to what happened with Cope. Cope was, as we hear from the rumors and people who say that they were first-hand witnesses, a political project sponsored by former President Thabo Mbeki. He was not on the ballot. He did not campaign for Cope, but Cope was still able to gain a large support base at about 7% in the first election. That definitely did damage ANC's outcomes in that particular election. So right now, we have a similar situation. Jacob Zuma is not going back to parliament. He's still the leader. He's still going to be campaigning. We just saw Concourt have a massive rally over the weekend where over 40,000 people showed up to Orlando Stadium. So they still seem to have the resources. They still seem to have the energy. As I've said to you before, many of the people I know from different political parties, different political leaders, have said that they have seen MK on the ground and that they're very active. So they're not running a digital campaign, a Twitter campaign. They seem to be running a campaign on the ground. Now, I want to give my reflections on this whole legal journey that Jacob Zuma has been on and a concern that I have. The concern that I have is that in the pursuit of Jacob Zuma, we may have undermined the value and integrity of the right to appeal. The right to appeal is an important right in many jurisdictions because it's something that was not afforded to people during times of oppression and repression. And also it allows for the correction of errors. It allows for the mitigation of sentences. It allows for correction and creation of conformity and uniformity. And also in many instances, it also allows for the building of public confidence. But fundamentally, it also allows a person who has been convicted to be able to reacquire their freedom if there's been an error. That seems to me to have been undermined. The effect of everything that has happened is that there's a category of persons who cannot exercise this particular right because they are in a forum which is final and immune from appeal. That makes me uncomfortable. That does make me uncomfortable because if you get taken directly to the Constitutional Court for whatever issue and it exercises penal rights, you can go straight to prison. Straight to prison. Let's say you're Vodacom, you're arguing with this guy about money, and then the court says, no, actually you committed a crime, go to jail. Not to say that's what would happen. It's not likely. But the fact that that can exist as a thing that they can access in their back pocket makes me very uncomfortable with this decision and everything that created this decision. As I've said before on the record, I think that Jafta J and Theron J were correct in Zuma 1 and Zuma 2. I think so. I think that a serious mistake was made by the Constitutional Court by allowing Chief Justice Raymond Zondo to use his influence and position in the Constitutional Court to bring the Zuma walking out of the State Capture Commission directly to this court. I think that there will continue to be debates about this particular issue, but I am personally worried that the right to appeal does not seem to be something that is of deep concern to the Constitutional Court, which ought to be protecting the rights of all civilians. I don't know what I'm weighing this against because I'm not particularly sure at this point what the public interest is versus the right to appeal. I think that the right to appeal is more important and one of the most important rights in the Constitution. You may disagree, but that is my view. And it's a legal view. It's not about Zuma. It's about the right. You know, when they reported VBS and they said that the EFF were the VBS looters, I thought that can't be right because they're not the ones criminally charged. They're not the ones who benefited. VBS was billions of rands that were stolen. And from the reporting I could see, they were saying that the EFF benefited 16 million. And then I thought to myself, okay, if they benefited 16 million, they are at worst an accessory, but they are not the perpetrator of the offense. And I defended the EFF when the media attacked them and said that they were VBS looters. And up to now, I don't think that the EFF are VBS looters. I think that the looters of the VBS are the politicians who were running the municipalities, the executives who were running the bank. And if you look at the political connections of many of those people, you will find that they're not actually associated with the EFF. They're associated with another party which runs Limpopo and has been running Limpopo for a very long time. So sometimes you can stand for an idea or an ideal without necessarily supporting the people, right? Jafta J is not an EFF member. Theron was not an EFF member when she sided with Zuma and said he had a right to appeal. In the same instance, you guys may not know this, but during Fees Must Fall, I protested against Jacob Zuma. During the Zuma Must Fall marches, I marched to Pretoria. I even took part in debates on the internet around this. And I have many concerns about the Zuma administration. So I say that to say the fact that I'm saying that the right to appeal is an important right is not because I'm fighting for Zuma. It's because I'm actually fighting for the rights. And I want you guys to understand and appreciate that, because I have a legitimate concern about everything that was done here. And I think there was an abuse of power. And I also think that the original sentence was too long. I don't think that 15 months is a justifiable time for walking out of a court, especially the commission, considering all of the different dynamics. But that's a story for another day. That's a story for another day. What do I want to say in conclusion? I think we're going to have an interesting election. We're going to have an interesting time. I'm very curious to see how all of this has an impact on the next stages of the election. I think that, it's all going to depend on how Zuma reacts and how the MK reacts. But if they remain within the framework of conventional politics and campaign hard, they may still get their 5%. People think that they'll get more than that. I think they may get up to 5%. I don't think that they're going to get 10 or even 2/3, which was being spoken about. So that's where I'm going to leave it. I wonder what you think about the judgment today. Do you think it was predictable? Did you think that the court was correct in its reasoning? And I remember the last point that I wanted to make. I've seen some people say, yes, the electoral court was wrong because the constitutional court disagreed with them. I think that kind of an appeal to authority is not substantive analysis. Judges can agree and disagree and have correct legal, not correct, but and have compelling legal reasoning to do so. But at some point, you need to have what is known as finality. There has to be a final decision. There may be many judges who disagree with the reasoning of these constitutional court judges. No judges are perfect. The judges were not given to us by God, right? We chose them. They're human beings. They have political preferences, ideologies, and beliefs. And those who are just saying, no, it means that the electoral court was wrong, or the other people who are disagreeing are wrong, simply on the basis that the constitutional court judges agree with them, are not practicing any reasonable analysis or substantiation. There has to be finality. Someone has the final say. Sometimes you can be a managing director in a company, but if the CEO says 1, 2, 3, 4, 5, or the board of directors says 1, 2, 3, 4, 5, that's it. That's the end of the matter. You may be right, but you will not have your decision executed. I just thought I should say that in conclusion. Just because you have power, or just because the powerful entity agreed with you, doesn't mean you're right. But for the purposes of law and the way we work, that's finality. That's the end of the matter. That's the end of the road for Jacob Zuma in the South African legal system. What do you think? Let's have a conversation. Till the next one. Oh yeah, please like, subscribe, share, help this channel grow. It's a new channel, and I'm trying to do this kind of video analysis more consistently. So let the algorithm know that you like this content. Get into the comments. Let's have a conversation. I really appreciate if you watched all the way to the end. And I would enjoy having a conversation with you in the comments. Yeah, now that's the real conclusion. Peace.